Today will not be the first and not even the second in this conference panel on the famous or unfamous fundamental rights impact assessment. It will be just a panel that will give its own perspective in relation to an exercise that is complicated, like it's complicated every exercise of balancing, no? Between fundamental rights, and it will give its own perspective from different angle. What I would like to say is that there is not just one formula, no? We are not speaking about maths, thanks God, or unfortunately. We are speaking about exercise attempts to find a kind of sustainable balance between conflicting rights and also conflicting needs. I am Oreste Pollicino, professor of AI regulation at Bocconi University, member board of Fundamental Rights Agency that, by the way, is developing its own model, as you know very well. I'm not aware of the model, but I would like really to praise the FRA for this work, especially because the AI office, in a way, finally gave important trust to Fundamental Rights Agency. I think this is very important because in order to give a meaning to this agency, you should trust the know-how of the person working there. And believe me, there are great scholars working there. But there are also great scholars here. And this is why I would like, first of all, to share with you the engagement rules. Basically, we will have, all the presentation will be 50 minutes, and then we will have an audience for 50 for all. This means 10 more or less for each one. The audience will have a possibility of Q&A. We are so grateful that you are so many here for other 25 minutes, and maybe there will be then some closing remarks, but for sure it's more important the debate. I mean, there are for sure some important questions that should be asked. I'm not sure they will get an answer. I'm not sure it's important to have an answer now, but for sure it's important to try to focus on certain questions. Who, first of all, should conduct fundamental rights impact assessment, FRIA for friends? What roles for industry, for academia, for civil society? And then the how question, how FRIA can identify and mitigating systemic risks? And then the what question. What mechanism ensure that FRIA go beyond procedural formalities to deliver substantive protection? I think this is the most important point. Because if we do believe in FRIA, if we do believe in fundamental rights protection, we would be very disappointed in having an exercise that would be a bureaucratic stuff that is perceived as just a compliance exercise for company. It should be something more, no? It should be something more substantial, something value-based. But it's very difficult to shift from bureaucracy to a fundamental rights protection that's very effective. We will try to guide the discussion, as I said, with excellent panelists. I will present in the order that I have here on my document, and it would be important to be careful, mindful of the time. The first speaker in my document is Jordana Ivanova, European Commission. She is basically the head of sector legal oversight of the AI impact implementation in the unit responsible for AI regulation and compliance in the EU office, led by Lucilla Scioli. So I think that it's very important, her point of view. In particular, her topic will be AI Act and the obligations, the role of the FRIA, and especially, and this I think it's very important to hear from you, the next steps for the commissions. You have the floor.
Thank you very much. I'm really honored to be here, indeed, among so many distinguished academic experts. Do you hear me now better?
Yes,
Okay.
yes, a little bit closer. Closer, closer. Or shouting.
Okay. I'll try. So thank you very much for being indeed invited today to this panel with so many distinguished honorable academic experts working on the topic of fundamental rights, in particular the fundamental rights impact assessment. Indeed, I'm coming from the office, and I think we are all gathered today with quite a number of events at this conference focused on the fundamental rights impact assessment. Now that we have the AI Act that is fully applicable, and we have a huge responsibility for all operators that are subject to prepare, and we as the AI office also to facilitate the effective implementation. So I don't need to recall the Act. I'm sure you know all about it. But indeed, the whole purpose and scope of the fundamental rights impact assessment is to add this safeguard that is not just procedural, as you say, but really substantive additional mitigating measure as part of the overall framework of the AI Act, which covers both risk-based approach, but also whole life cycle approach. And this is really important just to emphasize the role of the fundamental rights impact assessment in the AI Act as specified in Article 27, because it applies only to deployers of high-risk AI systems, so very specific type of AI system, but it complements the whole framework that we already have. And here I want really to mention that fundamental rights within the AI Act are addressed through the whole life cycle, including the responsibility of the providers of those systems that are already placing them on the market, and all the important safeguards that are at play. So we should not look at it only from the isolation what is in this article, but really from the perspective that in terms of an instrument that applies only at the level of deployment use, it complements already all the mitigation measures and risk assessments done by the provider. So what is the scope and responsibility for the deployers is indeed after they have received information and important certification from the system done that they are deploying as a high-risk AI system in certain very specific areas, is in addition to address and look at this residual risk and risk that can really arise from the specific context and use of the system, and then take the additional mitigation measures that are very clearly specified. And the responsible entities for this are mainly public authorities. That is very important as they have important responsibilities for quite a number of high-risk use cases in our Annex 3, but also private actors that are providing public services such as schools, hospitals, as well as certain other private actors. In particular for the credit scoring and also the insurance sector. So within the overall context, there is the obligation that adds on the top of all the mitigation certifications that are done, and this is an important exercise where the deployers have to clearly document processes, assessment, mitigations, look really at the particular specific context of use that is really important to properly understand and assess the risks to fundamental rights and accordingly take relevant measures. And here they really have to document human oversight and these assessments. Indeed, it's not one single solution, but it is an important process that has to be put in place, and fundamental rights here are understood comprehensively, of course, taken into account the specific use context of each use. So, for that exercise, the implementation, we fully agree with the point that was made that this, to be substantive and to be effective, it has to have the relevant people involved from the teams to make it work. Our objective as the office is to make it as well simple and clear for deployers how to implement it, providing both guidance but also specific templates with guiding questionnaires. And indeed, as was said, we are very happy that in this exercise we do collaborate a lot with the Fundamental Rights Agency. We've been working and we of course want to further develop, engage, and also further test in practical use cases based also on feedback with stakeholders, how our approach can effectively be implemented in an easy way and get this feedback before we officially adopt the questionnaire. So it's really part of our efforts to facilitate, develop also once it's available, an automated tool to help guide and also supporting guidance, and then have this as the overall support and guidance for the companies and also public authorities to implement it. So I'm really interested also, as we know there are a lot of other examples, and we do want to take into account and also make them fit into our approach and ongoing work. So just also to mention that we are going to have soon consultation on high-risk AI systems, where the FRIA is also an important element, where there will be additional opportunities for all stakeholders to provide input on this. And as said, as we are developing our questionnaire, and we are very interested to engage with stakeholders in very practical, specific use cases to implement it in practice and give good practice examples. So I stop here.
Thank you very much. Very, very clear. And just two footnotes. The first one, that the European Commission, it's very important, on the one hand implements, on the other hand ensure legal certainty. I think it's very difficult for you in this moment, especially as far as the guidelines for Act are concerned, because it's so complicated, sometimes it's vague, at times that you need many pages to explain, and this might have an impact. But there I have also, in terms of legal certainty, also in the first row, one of the most prominent members of legal service, Luigi Malferrari, that will say something. By the way, is the author of European Media Freedom Act, we can say, one of the main architects. Having said this, I would like to pass to a very prominent scholar, a great friend that I met at the annual meeting of the American Law School so many years ago. And I think from there I fall in love, just virtually, with him. It's Neil Richards. It's many things at the same time. He holds the co-professor of law at Washington University. He's a consultant and expert in privacy cases. He's fellows at Harvard Berkman Center at Yale. I could continue, but I will exhaust my time. So what I'll ask you, if it's possible, to give your very interesting original angle about FRIA, which is your view from a transatlantic means not only Americans, because you know very well the two sides of the ocean in terms of legal culture. Please.
So thank you, Oreste. It's wonderful to be on this panel and to be back at CPDP. I feel a little awkward because Oreste just professed his love to me, which was sincere and wonderful, and now I'm going to be really critical of FRIAs because I don't think they can work. At least I don't think they can work as a substantive device. Just I think to build on what Oreste was saying, that's I think is the really important question. And I think if I have to boil it down to one sentence, it's that FRIAs can be useful and DPIAs can be useful as an information forcing function to require exercises within entities to force them to ask the questions, to require them to document. But I don't think, unless you have someone who is a devoted fundamental rights ethicist running the organization, and how many AI members of the oligarchy are fundamental AI rights ethicists, I don't think it can work. I think it could work at a university, I think it could work at a research hospital, where there are this ethical substrate. So 3 points. I'd say I'll be brief. I think I will be brief, but that's in the CPDP bingo that I saw in that little, in the packet, so I don't want to offer that. Well, maybe I just did. So, three critiques: one internal, one external, and one epistemic. So the internal critique and this is whether it's FRIAs in general or the FRIA proposal that we were asked to comment on as part of this panel. I think that FRIAs, particularly if in the form that we saw, are intended to provide a score, a numerical, quantitative score, rather than a qualitative, ethical, information-forcing exercise. I think there's a great risk internally, within their own logic, of indeterminacy or variability along two dimensions. The first dimension is, and it reminded me how glad I am not to have been teaching this semester because it's grading time, and the FRIA rubric that we saw reminded me of my grade sheet for information privacy law. I worry very much about, let's say, vertical, we can call it vertical indeterminacy. When I am assessing the same student, the same course, or when the same entity is assessing its AI deployments, there's a risk of variability in between different instances. And then you can imagine a horizontal indeterminacy, which is different entities assessing the same kinds of deployments. And there could be variability there as well. I suppose we could even make it three-dimensional, and you could have different kinds of deployments. So instead of credit scoring, facial recognition or something else. And so I worry about if we're going to score FRIAs, I worry about the usefulness and the replicability of those numbers within entities, within individual contexts, or across entities within the same context, much less across entities within multiple contexts. So internally, I think we should be wary of numbers, even though the proposal that I saw was very thoughtful and very rigorous and asked very, very good questions. Second critique is external, and it builds upon a famous figure, or sort of conceptual fictional character in American law. Oliver Wendell Holmes, he wasn't fictional, but he invented a character called the bad man. And to Holmes, when we're thinking about how we think about the law, Holmes said we shouldn't ask what the aspirational value of the law should be. If we want to get down to business, we want to predict what a person is going to do when confronted with a legal rule, and we should assume that they are a bad man. So the bad man is this character. And there are, I live in the United States. There are lots of bad men. Some in positions of authority, some running technology companies, some both. And we want to ask ourselves what a bad man. Pick your bad man, and they don't have to be bad men. There's bad women too. There just seem to be more bad men right now at this point in history. What would they do with a FRIA? What would they do with a DPIA? And I think we know what they would do, and there's a pretty good academic literature on this. There's a lot of conversations every year at CPDP about this. They define the scores, whether they're qualitative or quantitative, to suit their goals. They don't care about ethics. So, some people do. Like I said, university medical centers, I think, are actually good at this. But if you think about a rapacious, openly traded technology company, they're not likely to do this. And I worry that without this ethical substrate, this deep ethical commitment that most people who come to CPDP have, and it's hard to think about the bad people that don't. But I think where the sort of religion of CPDP is not present, this deep-seated moral commitment to fundamental rights and to accommodating fundamental rights to the digital context and translating them, I worry that we would have the illusion of substance, but actually what would be going on would be the dilution, redefinition, and repurposing of FRIAs from a regulatory mechanism, from a check to a permission slip, to a recipe by which you can do whatever you want with the data, you can do whatever you want with the learning model, whatever you want with the other AI decisional mechanisms, and defining it that way. So what does that mean for FRIAs? I think it means we should resist the temptation to believe that they can be substantive, and I think if we think about them as purely information forcing, or maybe a commitment of ethical hygiene that at least these entities have to go through. I think that's the most we can hope for them. And so what did Holmes think the bad man was deterred by? It wasn't ethics. It was legitimate fear of punishment, fines, imprisonment, reputational sanctions, those sorts of things. Fall in stock price. Finally, epistemic. I was curious in the proposal that we saw about the push to quantify FRIAs, to have a score. And I want to ask a facetious question, which is, do we want AI to do it? Because AI is very good at numbers too. I don't think so, right? As I read the proposal, and as I understand sort of the basic impulse behind FRIAs, we don't trust AI. We want humans in the loop because we don't trust AI. But I do worry about any shift from qualitative understandings of things like fundamental rights to attempt to quantify them, because that seems to buy into this epistemic shift that we're living through in our lifetimes, that numbers seem to matter more, even when those numbers are made up. And so I would caution against the wish to quantify everything. I was being facetious when I asked whether we should have large language models or other AI decision makers perform these for us. But I think there's a parallel between the idea to quantify things and the broader epistemic shifts that make large language models, decisional AIs, even when they're sort of bullshit generators resting upon bad facts and bad data, appealing to large sectors of our society. So I will stop there and hope that was brief.
Thank you very much. Thank you also for keeping the time schedule, so we will have for sure time for a discussion. I'm sure will be fruitful. Very interesting, the shift from qualitative to quantitative. I understand, on the other hand, it's also true that the legal provisions ask for legal certainty in terms of quantitative damage. So it's complicated sometimes, to combine aspirations with legal obligations. But this is exactly an exercise that, by the way, gives the access to the next two speakers, gives me the possibility to introduce, first of all, them. They are Federica Paolucci and Andrea Cosentini. The first one is a postdoc in Bocconi University. The second, Andrea, is the head of the AI and data at Banca Intesa. All together with the team, this for sake of transparency, I want to emphasize, we have proposed one of the different models in which it's possible to give some practical injection to FRIA, because on the one hand, it's true there should not be a bureaucratic stuff. On the other hand, should be somehow practical. Otherwise, maybe it's not effective. But I will stop here, and I will give the floor, I suppose, first of all to Federica, and then to Andrea. Thank you.
Thank you very much, Professor, and thank you to our panelists for joining us, and thank you all for being so numerous and interested in this topical matter. I will just ask to change the screen and put the slides. Thank you very much. So as the professor mentioned, I am Federica, and at Bocconi we are working a lot on fundamental rights and AI at the moment, and not only with the team that we are presenting today, and I just wanted to address a few starting remarks before delving into our model. First of all, with the FRIA, as also the speakers that preceded me mentioned, we have numerous issues that we must face. The enforceability, first of all. Secondly, answering to which fundamental rights. That is not a trivial question to be answered, because as also Neil mentioned, we might have different standards. What is the referral point? The Charter, also the ECHR. What should we take into consideration? Broadening up to human rights or just focusing on fundamental rights? Maybe theoretical question, but something that we should answer at some point. And last not duplicating the efforts. So this is something that it has been told to the European digital policies in many aspects to not duplicate the compliance efforts, therefore trying to find a solution that can be in a common language, not only between different countries, but especially on different compliance measures that companies and entities in general should be implemented. That being said, our focus was not trying to answer all these difficult questions, but at least trying to make up an idea that can be, first of all, a compliance measure that can be implemented in practical terms by an entity. And that is what we did. And secondly, and very humbly, we will try to present this model as a possible template, practical template, as also was suggested by the first speaker that can be applied in the future. So not only good principles, but also something very concrete. And in our model that you can check in the QR code, and especially this model is presented through a paper, and then its annexes, is the collaborative effort of a multidisciplinary team. And I want to address this aspect before moving on, because one of the main issues of FRIA is exactly to put on the table different disciplines, different backgrounds that most of the time don't speak with each other, because something that can be very one-to-one for a computer science is not one-to-one at all in law, because as we know, law is not black and white, it has a lot of color and should be like that. Therefore, first of all, we try to find a common language. That's the first thing. And we think that the multidisciplinarity is one of the key elements of FRIA that should be implemented not only in the design of the model, but especially in the actual implementation of the fundamental rights impact assessment. Article 27 leaves a lot of space to entities and public and private actors to figure out what to do with the fundamental rights impact assessment, but we try to break down at least two, I would say, moments of the fundamental rights impact assessment, an ex ante, therefore before the deployment, since the first word in Article 27 are exactly prior to the deploying of the system, and secondly, the continuous monitoring. So to act not only when we have a threat or a harm, but a continuous monitoring of the performance of the system. The approach, therefore, that we followed, you can find the table in the paper, therefore don't worry if it's too little here. You can find it in the paper, in the policy paper. We try to make, once again, a system that does not duplicate the efforts. And in this, I mean not only a compliance effort, but especially an organizational one. Since FRIA in the wordings of the AI Act was created for deployers, but we asked ourselves many times, but what happens if I am also the provider? So if I create my own technology, how the FRIA communicates with the risk management system under Article 9? Therefore, once again, we try to make a system that talks with other obligations under the Artificial Intelligence Act, and we're working to find a common solution with a data protection impact assessment idea. What I want to focus of this methodology that was developed by the team is the two moments, basically. As I mentioned before, we act not only during the actual implementation, deployment of the system, but we start before. And we start before not only theoretically, but also in a concrete way, in order to understand the qualitative and the quantitative impact of the deployment of an artificial intelligence system. And we do so creating a way in which the law and the computer science speak together. I heard a lot also in other panels the fact that we have a fear of creating fundamental rights, and it's not only a fear, it's also something that is not super legal, to be fair. Therefore, the issue here, the solution here is for sure not creating fundamental rights, but have a concern, have an understanding of what is the actual impact, what this action triggers, not only towards fundamental rights, but especially in individuals, the people that might be impacted by the system. And in doing so, sorry, too fast. Okay, no, it doesn't go backward. Okay, in doing so, as I said, we developed a qualitative and quantitative tool. The qualitative tool is namely a questionnaire that is divided to thematic areas that involves not only the actual use of the system, but how the system has been trained, therefore assuming a direct collaboration between the deployer and the provider, a collaboration that is vaguely mentioned under the Act that we support and we encourage. Otherwise, it would be like for the deployer to be a bit of a fortune teller. How do I know if the system has the representative data, for instance, of the activity that I want to conduct? And a quantitative tool that is made of a matrix, of what Andrea will speak more thoroughly in a second. And all of this is combined with a strict legal vision of fundamental rights through a vademecum, a guideline that we created that commends all the 50 fundamental rights of the Charter through questions and an analysis that is prepared from a team of legal on the basis of how the Court of Justice of the European Union interpreted that specific right. Because we started from assuming who is in charge of applying fundamental rights. The courts. Therefore, we need to understand how the courts developed an interpretation of how actually the rights are applied in concrete terms. Therefore, we created a guideline based on this interpretation that will guide the deployer in filling out the matrix. And that is a very important aspect of our model. I would say that it's one of the quid novi of our model, since it actually gives a picture of the legal issues in applying that specific fundamental right. They have a lot of beautiful words, but they must be implemented in practical terms. Okay. Thank you. Now I pass the word to
Thank you, Federica. Thank you. As Federica told you, our approach to be compliant with the regulation for the fundamental rights impact assessment is based on two complementary and different tools. A questionnaire that assess the operational technical context of the AI system, and a matrix that assess the risk for each fundamental right. We have two outcomes. The outcome of the questionnaire is a questionnaire risk indicator that is a risk indicator for the entire system. So we have just one number. The risk indicator is a risk indicator for the entire system. We'll see more in depth later. And the output for the matrix is an impact significance for each fundamental right. So we have 50 risk scores that are the output of the matrix. The combination gives us the FRIA score for each fundamental right. Let me spend a few words about the questionnaire. The questionnaire is an assessment of the entire life cycle of the AI system, including the key actors and the stakeholders. We designed the questionnaire with multiple choice questions with risk levels that varies from 1 to 10, One important thing is that we introduced some blocking responses that stop the assessment if they are not in line with the regulation. The questionnaire is divided in 6 sections, plus 1 preliminary section. The preliminary section is where the system is deployed, who are the users, who are the potential affected persons, and so on. The section 1 is about the models and algorithms that the system use, including if the system use some general AI tool or model in the system. Section 2 is very important because it's related to the data governance and data quality implemented for the input data and the outcome. So if there is, if the data is under data governance process, if there is a bias assessment of the data, and so on. Section 3 is a check of the explainability of the model. So how much we can explain through some explainer of the outcome of the system, if it is a black box or is totally transparent. Section 4 is technical performance. Section 5 is very important because it's related to the human oversight process. We can see some sample questions of this section on the right. We can read the first one, what is the degree of decision automation in the AI system? If my answer is the first one, the decision is made by a human and the AI system only provides an additional layer of information, depending on the process, I can choose a risk level between 1 and 2. Otherwise, for example, answer number 3, the decision is based on the AI system, but it is possible for a human to ignore the result. Depending on the process, I choose a risk level between 5 and 10. But if I answer the number 4, the decision-making process is completely based on the artificial intelligence system with no possibility to ignoring the result, this is a blocking response. So, if we select this answer, this questionnaire shall be suspended and the system has to be redesigned. Idem for the sample question B, the operation of the AI system can be interrupted via a stop button or CBR procedure. Depending on the process, we can choose a risk level between 1 and 10. No, it's not possible to intervene. This is not aligned with the regulation, so the questionnaire should be suspended. It is not possible to proceed with the system. Few words also, okay. No. So just to recap, the outcome of the questionnaire is just a number for the risk indicator for the entire system. We have specific risk indicators for the 6 sections and 1 total risk indicator for the entire system. The matrix has 50 lines, 1 line for each fundamental right. We consider 2 main dimensions, severity of harm and probability of occurrence. Both are considered 2 subdimensions. For the severities, the intensity, so the maximum conceivable level of harm to a fundamental right, and the effort of remediation to reverse a malicious outcome. The same for probability of occurrence of harm. We have the 2 subdimensions, the likelihood, so the probability that the AI system generates an outcome that impacts a right, and the robustness, technical robustness of the system. If we combine at the end of the matrix the the two main dimensions, we will have an impact significance for each fundamental right. So each fundamental right of for the system has an impact significance. There is a tool online you can try to fill the metrics in the questionnaire. So at the end, we have
1 minute.
1 minute. Okay, thank you. We have to combine the questionnaire risk indicator and the impact significance. In a very arbitrary way, we propose this formula: 30% weighted the questionnaire, 70% the impact significance, to obtain a FRIA score for each fundamental right. This is arbitrary proposal. In our view, if every score is below 50, the system passes the evaluation. If one or more score is between 50 and 75, the system requires mitigation, so it's not possible to proceed. If one or more scores are above 75, the system cannot be developed and must be reevaluated. Also, these thresholds are arbitrary and maybe depends on the domain. We applied this approach a very plausible use case on credit. You can read it on our paper. Thank you very much. Sorry for the delay.
Perfect timing and also perfect logic, I think, in the different speech, because you see, after this exercise, there will be the final speech by Locke Morrell, that Tilburg University and Morrison and Foster, in which basically she will, in a way, ask and in a way raise an important question, I think, I suppose, I hope. And this is the following. Okay, those exercises are very important, but how is possible to, in a way, inject in the AI design? And we know that for the, as you said in your abstract, for DPI, for the PIA, for data protection impact assessment, there are some issues in order to, you know, to try to match theory with practice. So starting with this, starting with your great know-how, especially about AI responsible, one of the best, most well-known scholars in this field, I would kindly give you the floor.
Thank you so much. Yeah, some practical thoughts when I read about the FRIA is that it applies to the deployer of the technology. And just imagine that if there is an impact on fundamental human rights, often the AI tool is trained on personal data. So when you collect the data then and train the algorithm on it, it is the controller, the provider of the AI, who already needs to do a data protection impact assessment. It is possible to have a tool that isn't trained on AI or on personal data, but then actually impacts individuals. Let's just imagine you would have court cases, how to decide, and the AI is trained on decisions without personal data, and then ultimately you deploy the AI to an individual, and that would be then processing on personal data because you connect it to an individual, and then the deployer would need to do a DPIA because it is applying the tool to an individual. My point is, I found it very difficult to find situations where you would have a FRIA without a DPIA either already being performed or needing to be performed. So that is just as a start. Having done, because the AI Act wasn't there yet, having done many DPIAs on AI projects, whether it was for the developer or the deployer, you always take along the other fundamental rights because you need to check, you know, what the impact is on the individuals and society, and that's not just a privacy impact, but all of it. And I have done let me see. Yeah, I'm going to be the party pooper today, but I'm glad we already had one.
Thank you, I think.
Yeah, I think, yeah. Well, my point is, look, I have assisted companies, organizations, public authorities when they were stuck with their DPIA, or different department did one and were completely, wildly diverging outputs. Doing a DPIA and scoring, or whatever system you want to apply, is very difficult because it is an assessment of, and to give that a score is very difficult. But another thing is, and now people will be upset, but I see companies and also the government being well able to do a risk assessment from their own perspective, what it means for them. But to do a risk assessment from the perspective of the individual and then think about what it could mean for society is just not something they are trained in. They cannot do it. And part of it is because we came from a very stable society and we're now completely in a digital transformation. But look at the financial sector. They had rules for everything. The thinking is that if something is not prohibited, it is thus allowed. They lost any skill to do a contextual assessment, to apply in a contextual manner a new situation with their moral compass in place. I mean, they don't have it anymore, at least they didn't train it because the rules were so specific, and a new issue popped up, they would, you know, it would be issued with further guidance, or then companies need to predict the future, because otherwise it's a new tool, you have no clue what the impact will be. Well, we all know the Collingridge dilemma. The whole point of giving this responsibility to companies to do their own risk assessment is because for the government, for the regulators, it's very difficult to predict the impact of all these new technologies. I'll give you one stupid example about, you know, I can give you 100 on how you completely misjudge the impact on society. Remember when the first mobile phones were there, you know, all the interviews, oh, I don't need a mobile phone, I don't want to be reached everywhere. And now the same people have this thing next to their bed and will never even go in the shower with it. Or the internet and social media would, you know, improve all our connections and interconnections and communication. I don't know whether you see the younger, well, my children. I see it's an issue that they don't dare to call the doctor anymore because they find it difficult to communicate real time. They can't redact their text. Or they post so many nice photos of themselves, it's actually difficult to meet up in how on earth are companies going to score that type of impact in any assessment. So I see so many impact tools and DPIA tools and FRIA tools, and I see it, and they should be easy to use, and they should be clear. And I tell you, it is the level of input from really good organizations in their DPIAs or their FRIAs is dreadful. And that is not because that those are bad people, but it is very difficult to do. And even simple questions like the one, I'll give you one comment on the example you gave, but my experience with DPIAs and FRIAs is never the straightforward impacts, but ultimately whether a tool is acceptable and ethical, is responsible, is not impacting human rights, is not only looking at the impacts, but it is also a fair division of the benefits and the burdens, and that often with more parties in the ecosystem. And those questions never pop up in a FRIA. Or, maybe you can pop up the slide on the, you know, how you score whether it's humans have oversight. If the decision tree is pretty clear, I would be happy with no oversight at all, as long as somebody is monitoring the algorithm that it isn't off track. The AI Act, human oversight, is monitoring of the algorithm. If you have a scoring, in your example of financial credit scoring, the experience is that even if there are further criteria, people rely on the scoring. The European Court even said that scoring in and of itself is already automated decision-making, because you have confirmation bias and people just rely on the score, even if there is human... Shufa. So the point is, your highest score for a kick-out would not be a bar for me, and your lowest score would alarm me to the end. And that is because it depends on the context, etc. So trying to communicate that things can be called in such simple terms. My experience is, if you have a really innovative project, you need to train the whole innovation team on the impact of fundamental rights that could happen with this type of, and then try to teach them how to implement safeguards by design, how to turn around the model that is used in a different way, and then it becomes user-centric rather than company-centric. I'll give you one example. On my desk, it's your credit card scoring. The banks, in their online scoring, take along the chances of people getting a divorce, because online it is easy to monitor and score that. And the fact of life is, if people get a divorce, their life gets more expensive, and they start defaulting on loans, etc. Okay, objective fact. You can say, the banks say, well, this is in the interest of the financial sector. That's how they think, huh? They all say it, because if all the others are doing, if I don't do it, I'll get all the bad debts, I'll go belly up. That's not in the interest of the financial sector to be... and then the question is being married or not, is that discrimination? It's not one of the elements in our discrimination laws. And they don't realize that if we start giving loans to people who get a divorce, I tell you, we're excluding 1/3 of our population. Is that, in the public interest? I don't think so. Is this something, the privacy laws say you need to be transparent about it? So are you going to say, look, guess what, I'm testing your social media whether you get a divorce? Just imagine how I come back in the breakfast table. Are we getting a divorce? Oh, I didn't know. You intervene in people's... Do you see, a simple factor like that can have totally weird implications. And what you also can do is, I'm concerned about creditworthiness and all the factors, and that is also in the interest of the individuals. Maybe I give individuals, clients, an app where they calculate their score based on something you do not know, but the individual, and they get a free hour of advice if the flags are more red. My point is, the solution is not in the scoring, it is how you implement it. Yes, and that's why I don't believe in it. It gives a false sense of security. It triggers gaming, tinkering around till you get under the required level. Yeah. And I think it is a helpful tool to ask the relevant question. Did you ask the right questions? Did you look at the benefits, if they are equally divided, but also the burdens? All these types of things are more relevant for me than the whole scoring, which I saw many, and which are, they can't even explain sometimes why they gave it. They try, but it doesn't sink in. This is it for me, sorry. Going over time.
Oh, thank you very much. Now I would open for the Q&A, but I'm sure there will maybe some able to reply from our other panelists, because there was an interesting discussion. You think not only on the merit, but I would say especially on the methodology. This is maybe more important, no, than the merit. There is not one solution. For sure, it's very complicated to give substance on the ground to principle like human oversight, fairness, explicability. This is one of the most important challenge, you know. But we are not here to discuss. Maybe in the next paper. But now it's time, I hope, for questions, for critics, for doubts. Yes, I see 2 or 3 hands. I will give the floor to Luigi, and then to the others. Please, it would be nice when you speak to introduce very, very brief in 2 words. Thank you very much, and clearly very brief.
Thank you very much. Ferrari, European Commission. A question to Jordanka, but also to the other panelists. What is the role for the individuals concerned? As a fundamental right lawyer, I always think, you know, what is a person? When, does the person think about his status? So if it's a public authority concern, we can build on the general principle of a good administration. But what about if it's a private entity? The article says nothing about the role of the individuals. What could be also the possible beneficial effects of a possible statement, a possible intervention by the individuals concerned on the problems that all of you have pointed out. Thank you.
Thank you. I would collect at least 3 questions. I can help if you want. Okay, let's go there on the left, and then there is Gian Claudio also.
Hello, I am Joka. I'm a DPO for a Dutch municipality. And my question to the panel, I hear you all with your remarks on how to get the impact on society from those impact assessments. And when you do those, you hear the point of view of the organization. So how do you break out of it? What's your ideas?
Thank you. Gian Claudio, Professor Moggeri, and then Professor Moggeri, then there is another there, and then we collect the answers, please.
Very quickly, very interesting models. I also tried it. I wanted just to ask more about the severity. I see you break out severity into intensity and remediability, but the intensity refers to harm in a more quantifiable way. So maybe my point is also connected to the first question. How can we embed, first of all, perceptions of severity of different groups, in particular considering that severity has a subjective and group dimension, and also how can we escape this harm reductionism approach, like just damage, just quantifiable loss, no? There's much more. You can have non-discrimination without any quantifiable consequence in life. Sorry, discrimination without any, or you can have freedom of speech without any consequence. So my question is, about that, intensity and severity.
Thank you very much. There was the last question there, please. And then we will try to do a fifth round. The last question, and then we will try to do another one. We will see.
Thank you so much. My name is Mirko Tobias Schäfer, Utrecht University. I have a brief observation and a question. The observation is, and I noticed that all morning, it's the rhetoric of the subjunctive, as if this is something that happens in the future, but there are FRIAs that are implemented and used and documented, so it would be really great to really refer to empirical evidence and think in that line. And my question would be, what do you think about making them accessible and transparent? I agree with Locke that the power is in the implementation, so it would be great for audiences to be able to access them.
Thank you. I see there are other questions, but now is the moment of the first replies. I would start in the inverse order, but maybe yes, I will start in the reverse order, please.
Reverse order. The role of individuals. I was involved in the ethical assessment of the COVID app for COVID tracking, and we did citizen panels to get the input, and I tell you, it is helpful. clarifying. They come with different things than you could think up. So if you're a government and to think of groups that really test and also for accessibility, for readability, for stupid things, I thought it was really helpful. So yeah, there should be room for that type of, and it is actually helpful. Is it on all the questions or just the first?
No, just all. Very brief, if you can just address
Okay.
it, because I'm not sure it will be a second chance.
Okay. Well, severity for groups, obviously, some may be very beneficial. You need to distinguish, absolutely. The intensity of impact can be undermining of free speech in the entire society rather than specific individual impact. It should also count. What was the third?
Transparency.
Yeah, I have been saying for a very long time that I think DPIA should be public because sunlight is ultimately the best of disinfectants.
Great. Thank you very much. Very clear. Now, Andrea.
Written by Holmes's colleague on the Supreme Court, Brandeis.
I want to own it, but you take it away again. No. Joke.
Okay, very interesting this, but I would proceed with the order. Now, Andrea and Federica.
Okay. Yes. Okay. Our starting point is that we have to be compliant to the regulation. So we need a suitable approach that permit us to be compliant. Okay. Maybe our focus is the human oversight in the banking process. But it's another topic. We are discussing now about the fundamental right impact assessment. In banking system is absolutely regulated. It's not possible to have a process for loans without the absolute responsibility of a human, of a mankind. So this is the stage. But our approach is to discuss with you, with every one of you, how to implement a suitable fundamental rights impact assessment in order to be compliant with the regulation. About intensity, exactly, we have to discuss together because we can have different modulation for the same, maybe for the same use case about intensity. But this is okay. This is a point, but there is not the only one risk point, risk process that we have in the financial sector that is arbitrary. Then, when the regulator come for an audit, decide if our decisions is good or not. But we have to start from a common tool in order to permit us to be compliant.
On the legal matter of this story, so just a comment on the first thing that was mentioned, the fact that Article 27 doesn't say much about individuals. And to be fair, the whole AI Act doesn't say much about individuals. Sorry for the provocation. And this is why in doing the FRIA, we try to focus on this very aspect. So I'm connecting also with the Professor Malgeri's question about the severity and intensity, to not just focus on the violation of the fundamental rights, that it's something that would be to avoid at all. So do not arrive to that point of risky reaction of the AI system. This is why we embedded a perspective that is not only reactive, so when we have a problem then we react, but also preemptive, and that is the most important part, to figure out mitigation measures that do not only take place when we have a problem, but all over the life cycle of the AI system. And once more, as I mentioned before, this is why we suggest to do the FRIA not only when you have a problem, but in a procedural way that is specifically listed in the policy of the entity, of the public actor, or whatever we are facing as a deployer. This is why, and my last point is that in the FRIA we should look also to other experiences like the corporate sustainability due diligence, for instance, or the hood area approach that was suggested by the Council of Europe under the Framework Convention, which is not binding. Still, is something very interesting to look at, since they focus a lot on stakeholder engagement, and we really think that this can be the key to actually give the voice to the groups. So not only what the company or the public actor perceives as particularly relevant in terms of risks, but practical understanding, hearing from the people, which is something I would say super positivistic in terms of private actors, that they don't want to do it, and they might have a point, because they say how you put the nose on my decisions. Still, the only way we can do it is to be transparent, as also Professor Mole mentioned, and not only conduct data protection impact assessment or fundamental rights impact assessment for the sake of it, or just to be compliant, but to make sure that the system that is implemented doesn't pose a violation or a harm or a risk to anyone. So in a nutshell, transparency, but combining a practical way through the mitigation measures Andrea spoke about, so human oversight and stakeholder engagement. Thank you.
Thank you very much. In this, maybe it would be possible to extend the scope of application. I would not be surprised if FRIA will not be basically adopted only by deployers at high risk, but would be extended in terms of reputation measures. Mm-hmm. We will see but it's not now the topic of today. I agree. But Neil, please.
So I really liked how all of these questions sort of circle around the problem of self-assessment, which is essentially what we're talking about here, right? That I'm an impartial observer. I grade people all the time. My wife will tell you that I'm not very good at judging my own successes or failures or flaws. Self-assessment is inherently biased, and that is particularly the case where self-assessment is self-interested, where there's money at stake. And so I think particularly when we're talking about the private entities performing a public function that are covered by this provision of the AI Act, I think we're deluding ourselves if we don't think, and this is not a criticism of the paper, it's a criticism of the AI Act, sort of assuming a solution. They had these things, these data protection impact assessments, they're adopted from environmental impact assessments. We've solved the problem of the environment through environmental impact assessments. We've solved the problem of data protection through data protection impact assessments, so now we're going to solve the problem of AI. It's the third time it's going to work. I worry too, and this I think goes to John Claudio's point, not just the bias, the self-interested bias, but a situated bias, right? That we're very bad at judging the future. We're very bad to Loca's point. Yeah. Right, so I'm holding a TikTok pen. Do we think TikTok is really good at judging the social benefits of their highly addictive platform? No, right? They can't, and maybe we shouldn't expect them to do it at a level of moral clarity, because they're just trying to make money. And there are reasons that's not a justification for what they do.
Moral folk.
Right, moral hazard, right? That, and I think that TikTok's a deeply addictive product that has probably there's good evidence it, like other products, has really bad outcomes, mental health outcomes and attention outcomes for young people in particular. But they can't judge that. Or if we ask them to judge that, they're either going to lie. They're either going to lie to themselves or they're going to lie to us, or both. And this, I think, is where the transparency point really comes home to bite. And I think there's a trade-off here in transparency between what we want data protection impact assessments to do. If we mandate and transparency is important, but if we mandate transparency from TikTok's addictive mental health to children, for example, impact assessment from its AI algorithm, to keep this on AI, TikTok's lawyers are going to get involved. And so if we make them publish it, it's going to be like their privacy policy, right? It's going to say nothing. And that's not a comment at TikTok's privacy, it's a comment at all privacy policies. If we want them to engage in an ethical, soul-searching, long, dark tea time of the soul, where they sort of, they think about their moral core, maybe we don't want them to publish that. And I think there's a trade-off between those two things. And so while I think transparency is important, it might actually thwart or further thwart the exercise we're trying to achieve with the data protection impact assessment, whatever we decide that is, whether it is information forcing or whether it is ethics embodying into the entity.
Thank you very much. I see that there is another question, but if you don't mind, I would like to give the floor to... yes, because you deserve the final word, and then I would be happy to take in 2 minutes your final question. Please.
Yes, thank you very much. Just to complement that, the affected person, the individual, is at the center of all the measures that the AI Act takes. Actually, the second thing that deployers have to think about is who are the affected persons and groups of persons, and even focus particularly on those that are vulnerable, and even consider the different impacts and fundamental rights, taking into account the different groups. Already in our guidelines, for example, for the prohibitions and the exceptions to real-time remote biometric identification, of course, the use can have very different impacts for those that are in the database and the rights that are affected compared to those that are just, for example, passers-by subjected to the facial identification technologies. So it is there, it is at the center for both already, also even the provider, when they have to think about the risk and assess, mitigate those risks in view of the intended purposes. So that really makes the Act a bit more adding value already also to other risk management, and that, for example, banks are just doing for their own organizational. Yeah, I think that is really important to emphasize in general, and that includes also the impacts of the groups. And just also to add, in terms of the transparency and the accessibility, the AI Act does requires that a summary of the impact assessment becomes public in a public EU database for all these high-risk AI systems. So actually, there is a lot of already transparency. It is true that doesn't require third-party auditors and other things before, but this public transparency for what can be still informative for the public and also for the people is really important. And that's complemented also with information rights for people to be informed that, for example, high risk is used, or even right to an explanation. And the Act doesn't require in particular that indeed affected groups or persons are consulted in the FRIA, but this is an element that is also recommended in the recital. So especially for the public sector, but in general, indeed, to make it effective, that could be a good practice. And of course, this tool is still supervised by competent authorities, so this is not a free way, and it does require to be meaningful as well when it's implemented.
Thank you very much. I think that we have 2 minutes left. I'm sorry, just to give you the floor to the first one that raised the hand, please. If you can introduce yourself and very briefly ask a question.
Michele Lui, Algorithm Watch. So given that the actor that needs to do the fundamental rights impact assessment is the deployer, and this deployer may either develop a tool internally, but also in many scenarios will just purchase it from outside. in many cases, this deployer is also a public entity. We may think the person responsible for certifying basically the risk assessment may also be risk adverse. So have you thought about what are your assumptions? What are your assumptions about how this plays in the ecosystem? Like who will react? How will this assessment be an input to a further process, either internally or in relation within purchasing a service from the market? What have your assumptions been?
I think that it's, especially for Federica and Andrea, 1 minute each, and then we have to conclude.
Thank you, Lo, for the question. I believe that the problem that you're mentioning is the relationship between the provider and the deployer, and as also the Professor Pollicino mentioned before, this FRIA can also be something like reputational way. Still, we need to enforce, and I totally agree, this relationship between the one who actually produces the thing and the one who actually uses. Still, this dialogue has been not super implemented so far by the regulation, because on the one hand we speak of a risk management system that also speak of fundamental rights, but it's not fundamental rights impact assessment. On the other way, we have the specific article, Article 27. This in the table that we created, we highlighted how this relationship can be made through the same tool. So we actually spoke in our paper about the fact that the FRIA doesn't only need to involve the deployer, but can be conducted all over the life cycle of the system, and it's advised to do so and to interpret Article 9 in a broader way. Thank you.
Please, Andrea. Okay, no, okay. Okay, I think it was a very interesting debate. Clearly, many things, many takeaways, many lessons to be learned. If there is one thing, I think that is clear that for sure it's wrong who thinks that he has the solution in the pocket, no? Especially as far as the right formula. There is not a right formula. There are attempts, some are good, some are better than others. What I really liked it's, at least in this room, the idea of a pluralism, like a laboratories of ideas that is really growing, not only a debate, but maybe also the final result. So many thanks. Have a nice coffee break.